Thank you. We are back. All right, let's do a bunch more videos. We're not going to spend a lot of time on this, but let's go through some of the basics of joinder. Let's start off with two important preliminary things to keep in mind about joinder. First, joinder refers to joining in additional parties or additional claims. All right? So when P sues D, that's your original claim. That's not joinder. If P sues D1 and D2, that's joinder because we're adding in an additional party. Okay? The second thing to keep in mind about joinder is that the question of joinder is a question separate from whether or not there's going to be subject matter jurisdiction over such a claim or such a party. All right? Read the question carefully. If the question asks you to discuss joinder, limit yourself to joinder. Don't talk about SMJ. If the question's about SMJ, you don't need to talk about a joinder unless joinder becomes relevant to SMJ. Here's an example of when joinder is relevant to SMJ. Supplemental jurisdiction, right? Because under Section B of the Supplemental Jurisdiction Statute, we may have divestment of supplemental jurisdiction in certain joinder scenarios, in which case you will need to address the sub-issue of joinder. But there, joinder is a sub-issue of SMJ. All right? So, keep in mind that barring that, they're separate issues. Corollary to this second matter, right, that SMJ and joinder are distinct questions, is that the existence of joinder does not guarantee SMJ, and the existence of SMJ over a claim or party does not guarantee joinder. So a very brief example, P sues D1 for copyright infringement and sues D2 for negligence arising from a car crash. Let's assume the parties are completely diverse. All right? So here we have Florida, PA, and PA. Will the court have SMJ over this lawsuit? What kind of jurisdiction is asserted against D1?
Federal question.
Federal question and copyright, right? How about versus D2? Diversity, right? There's SMJ over both claims. Are the claims properly joined? Are they properly joined? What kind of joinder is this? Rule what? Rule 20. Under Rule 20, the claims against these two parties have to arise from the same transaction, occurrence, or series of transactions or occurrence. Do they? Would appear not, right? Copyright infringement versus a car wreck. So claims are not properly joined under the rules of joinder, but there would be SMJ over them. Okay, separate issue. And I'll leave it to you, but you can certainly change the facts around, and you can come up with a scenario where there would be claims properly joined, but SMJ would be lacking. All right. Those preliminaries in mind, let's jump a little bit more deeply, but not super deeply, into the questions of joinder. To start off with Rule 13, right? Counterclaims and cross-claim. We did this earlier. P versus D1 versus D2. All right. If D1 goes back, or D1 goes back against P, that's of course a counterclaim, CC. And if D1 goes against D2, touching something here. Behave. All right. That's of course a cross-claim. All right. First thing to keep in mind is cross-claims, D1 versus D2. Is there such a thing as a compulsory cross-claim? There is not. Cross-claims are always permissive. All right? Second thing, is there such a thing as a compulsory counterclaim? Yes. So let's start off then with counterclaims, the distinction between compulsory and permissive. If you get an issue involving a counterclaim, then you're going to need to figure out whether it's compulsory or permissive. All right? Note the interesting wording of permissive counterclaim. It's anything that is not compulsory. Any counterclaim that's not compulsory. It's defined in the negative. So to determine whether something is a permissive counterclaim, by definition, you have to figure out whether it is or is not compulsory. So what is a compulsory counterclaim? Well, y'all like to say it means the same TRO, right? Same TRO. Counterclaim is something, a claim that arises out of the same transaction or occurrence as an opposing party's claim. Well, yes and no. Same TRO is part of the definition of a compulsory counterclaim under 13A, but it is not the entire definition. It also includes ripeness. It also includes not requiring adding somebody who's going to kill jurisdiction. It also includes the fact that the counterclaim is not already pending in another action. And it also includes some stuff about quasi-interim jurisdiction that I'm not going to get into in this course. So I note that part A to B is there, but I will test on it. All right. Instead, let's talk about these elements here. Same TRO, right? Ripeness. Oh, wrong place. Same TRO. This is the ripeness requirement. It has to be a counterclaim the pleader has, present tense, against the opposing party at the time of the counterclaim service. That means any counterclaims that arise after the time the answer is served aren't counterclaims that can be compulsory. All right? So the later occurring counterclaim doesn't matter. That's what we call the ripeness requirement. We've got no jurisdiction killers here, right? So for example, if you have to add another party that's going to destroy diversity jurisdiction, then the counterclaim is not compulsory. If the party to be added would lack PJ, then the counterclaim is not compulsory. Finally, a counterclaim is not compulsory if it's pending in another action. So say, for example, X sues Y for negligence in state court. Now, Y sues X for negligence in federal court. Let's assume the claim asserted by X in suit 1 and Y in suit 2 arise from the same car wreck and are thus the same transaction or occurrence. Here's my question. If X has a counterclaim against Y, would that be compulsory or permissive? Let's go through our checklist. Is the counterclaim, here we're talking about X here versus Y in suit number 2, federal court. All right? Let's do them out of order. Does the counterclaim in suit number 2 arise out of the same TRO? Does it? Yes. All right. Does it require adding a party over whom there's not jurisdiction? We don't know enough facts, but let's assume that's a yes. All right. Did the defendant in suit number 2 have a right claim, one that existed at the time of observing their answer? Yeah. Was the counterclaim the subject of another pending action? Yes. So is the counterclaim compulsory or permissive? Permissive. Even though it's the same TRO. Do you see why I emphasize compulsory counterclaim doesn't mean TRO? TRO is just an element of a compulsory counterclaim. It is not the entire test for a compulsory counterclaim. All right. Let me make another point about TRO, and this point is going to be relevant to a a lot of standards we see. Whenever you see T or O, or conduct, transaction, or occurrence, or you see series of transactions or occurrences, okay, or simpler language, you are being asked to compare one thing against another. Now, I know the Galena book says very unhelpfully that courts use tests such as the logical relationship test, and whether or not the subsequent claim would be barred by res judicata, and substantially the same evidence and all of that. So the evidence is a relevant consideration. I like that. But more fundamentally, whenever you see CTO, CNOF, right, supplemental jurisdiction, any of those similar standards, they are asking you to compare A to B, compare claim to counterclaim, compare claim to cross-claim, okay, and so on and so forth. Original jurisdiction claim and supplemental claim. Are they similar or are they different? In terms of things like evidence, timing, place, law, all right? This is a standard. Think about comparing the two and how they're similar and how they're different, and a counter-argument if worth making. And to compare A versus B, you got to tell me what A is, and tell me what B is, and then compare them. Just don't say, oh, they're from the same T or O because it's the same accident. No. What's the original pleading alleging? What's the counterclaim alleging? Or what's the supplemental claim alleging? Okay? Whenever you're asked to compare A and B, you got to compare A with B. All right. Let's move on. Let's talk about cross claims under G. I'll highlight here. Yeah, one pen. This pen. There we go. Now, first, of course, cross claims are always permissive, never required. Second, they're between co-parties, okay? So, cross-claim is somebody's when one co-party sues another. P1 versus P2, D1 versus D2, third-party defendant 1 versus third-party defendant 2, and so on. There's three bases for cross-claims. 1, 2, and 3. All right? Number 1 is a T or O. Same T or O as the original claim, the original action, or the counterclaim. All right? That's the first basis. So here you're complaining, maybe you are complaining. You're comparing the cross-claim to either an original claim or a counterclaim. Here's your second basis. The claim relates to any property, the subject matter of the original action. Okay? Now you're comparing the cross-claim to the property that's at subject of the original action. The third basis is seeking contribution or indemnification. Kind of like Rule 14, right? Now let's illustrate. P versus D1 and D2. So it's negligence and negligence for a 3-car wreck. P1 sues D2 for unrelated breach of contract. Is that a proper cross-claim? Is it? It is not, because it's not related to the original claims, it's not the same T or O, it's an unrelated breach of contract. How about this? D1 versus D2 for negligence. Is that a proper cross-claim? Yeah, so long as D1 versus D2 is from the same car wreck, right? So we have the same T or O. Note that when D1 is sued with D2, well, I'm not going to know, I'm going to ask. When D1 cross-claims against D2, whose damages is D1 suing D2 for? His own or the plaintiff's? Oh, I heard both. All right. How about this? Does this help? D1 asserts 2 cross-claims. The first one is negligence, seeking D1's own damages against D2. Is that okay? Which of the definitions of cross-claim does this fall into? Number 1, number 2, or number 3? Number Number 1, that's right. Same TRO as the original action. And here D1 is seeking recovery for his or her own injuries or damages. How about the second cross-claim, D1 versus D2 by way of contribution? Is that allowed? Okay. D1 versus D2 for contribution. Is that a proper cross-claim? I didn't respond to your yeses because somebody's... Yeah, please keep the talking down. It's distracting. All right, D1 versus D2 for contribution. Is that a proper cross-claim? Which definition? 1, 2, or 3? 3, that's right. When D1 sues D2 by way of contribution, D1 is saying to D2, hey D2, I'm suing you for contribution for anything that I, D1, may owe the plaintiff, because you're a co-tortfeasor. Kind of like Rule 14, isn't it? Why do we not repeat Rule 14 here? Because D2 is already a party. Rule 14 is used to bring in somebody new. Rule 13G is used to cross-claim against somebody who's already a co-party. And you can do that by way of contribution. Now that we have D1 and D2, we have, this is definition 1, this is definition 3. Can we add in the breach of contract, say an unrelated contract for the sale of a vintage red 1980s Kramer guitar? Can that be brought in? Is it a proper 13G cross-claim? How do we get in the breach of contract if it's unrelated to anything else in the suit? Rule 18. Rule 18 allows us to pile on. Rule 18 says that when we've already got a proper claim, counterclaim, cross-claim, third-party claim, you can then bring in as many. Rule 18, there you go. Once you have a proper cross-claim, you can join in independent or alternative claims that you have against an opposing party, even if they are unrelated. All right, so that's Rule 13G. Let's add one additional twist. Let's add one additional twist. We'll start off with a simpler fact pattern. Say you have P versus D, and P is suing D for copyright infringement, and D counterclaims for negligence arising from a car wreck. But guess what? It's a 3-car wreck. Can D bring in X in the counterclaim? Is that permitted? Rule 13H. Rules 19 and 20 govern the addition of a person as a party to a counterclaim or a cross-claim. You see that? What is D asserting against P? What's that called? Cross-claim, third-party claim, D versus P. What is it? Counterclaim. What kind of counterclaim? Permissive or compulsory? Permissive. Okay, good. All right. Rule 19 and 20 govern the addition of a person as a party to a counterclaim. This is a party added to a counterclaim, right? Would either Rule 19 or 20 permit X to be joined as an additional defending party on the counterclaim asserted by D? Which rule, 19 or 20? Which rule do you think might apply? 20, that's right. This is using Rule 13B on a counterclaim. This is using Rule 13H plus Rule 20 to add X to the counterclaim. Additional party, that's what X is to the counterclaim. Well, that seems like a good way of segueing into Rule 20, doesn't it? So let's take a look at Rule 20. Right? Note that 20 is permissive joinder of parties as compared to Rule 19, which is required joinder of parties. All right? Permissive joinder. 20A1 is joinder of multiple plaintiffs. 20A2 is joinder of multiple defendants. The standard in both cases is the same. First, you need any question, at least one, question of law or fact common to all of the plaintiffs if it's A1, or common to all defendants if it's A2. What if you have 2 P's and 2 D's, right? So this lawsuit looks like this. Are we using 20A1 or 20A2? Which one? What's that? It's both. It was a trick question. It's both. The multiple plaintiffs are joined under 20A1, and the multiple defendants are joined under 20A2. You see that? And that, of course, is permitted. That's how you get multiple P's and multiple D's. Well, question of law or fact common to all the co-parties, that's an easy one. That's not hard to satisfy. The harder one to satisfy is that the claims have to arise from the same transaction, occurrence, or series of transactions or occurrences. Okay, we had some cases, but won't refer back to those. This is another example of where you're comparing one thing to another. Now, in a Rule 20 scenario, let's have a simpler fact pattern, all right? D1 and D2. When you're saying that something arises from the same CTO as something else, what are the two things that we're comparing? What's being compared? What's that? That's right. This is the one thing you're comparing, and this is the thing you're comparing it to. The claim against D1 and D2. Do both of these claims arise from the same transaction, occurrence, or series of transactions, occurrences? That's right. That's right. All right. That is Rule 20. All right. Let's see. What else? Rule 19. Let's just cover that very briefly. Rule 19 is something we can spend just an hour on, and therefore I won't. There's 3 steps to the analysis here. All right, this is a wonderful formatting of a chart I've done for years. It was formatted very nicely by my ALI from several years ago, Christina Morales, so thanks again to Christina. There's 2 questions under Rule 19A. 19A being required joiner, right? We're talking here about a VIP who has to be invited, and if they can't come to the party, then you have to ask whether we have to cancel the party. That's the essence of the purpose of Rule 19. Well, the first step in Rule 19A is whether somebody is a VIP. In other words, they're an absent person. They're not yet a party because they haven't been joined. The question is, do we bring them in? Well, to determine whether or not they're a VIP, you have to look at 19A, which lists 3 scenarios, all right, where somebody might be a required party. And I'm not going to go into those right now. It's going to take more time than we have. I'm going to move on to other stuff. But go back through your class notes. Look at the examples I gave about the landlord, right, and about the escrow fund and all of that. If you're missing notes from that day, you see a classmate, and if you still can't find it, you come and see me or send me an email, or we can talk about it on Wednesday. But we're not going to have that kind of time today. Let's assume somebody is required and they've not been joined. The next question is well, can we join them? Indeed, under 19A, the second step is that the court must join a required party if joiner of that absent person is feasible. Feasible means they can be joined without messing up, among other things, PJ, SMJ, or venue. All right? If joining the absent person would destroy diversity jurisdiction, then joiner, of course, is not feasible. If the person who's absent would have a valid objection based on venue or PJ, then joiner is not feasible. In which case, we get to the final step, is do we cancel the party? Proceed without the absent person or dismiss. And here the court, or excuse me, not the court, Rule 19B gives us 4 non-exclusive factors to look at in determining whether or not to grant a motion under Rule 19. So the final thing I'm going to say about Rule 19 is, what do we mean by Rule 19 motion? Well, I suppose in theory, somebody might just move under Rule 19, say, hey, this person isn't in the suit, they ought to be in the suit, let's get them in. Hey, let's invite them. Come on, join the party, right? But more typically, Rule 19 is raised by way of a Rule 12b defense. Here it's a Rule 12b-7, A motion to dismiss for failure to join a required party. Required by what? Required by Rule 19. So the typical litigation tactic that gives rise to a Rule 19 issue is somebody suits some other person, somebody else is absent, and the defendant is trying to get the lawsuit dismissed on non-merits grounds. What grounds? 12b7 grounds. Why? Because there's a VIP that wasn't invited. There's an absent person who wasn't joined who's required, right? And what the defendant, the person that's in the suit, is saying is, hey, you sued me, but this person over here is absent and you didn't join them. And they're required to be joined. And if you don't join them, then you're going to have to cancel the whole lawsuit, right? You're going to have to dismiss the entire case, right? That's the real purpose in almost every case of a Rule 19 analysis. All right, let's move on. Let's talk very briefly about some of the other rules. One that I don't, let's see, a couple ones worth noting. Rule 21 notes the distinction between misjoinder and non-joinder. Misjoinder means that you join somebody when they shouldn't have been joined. For example, my hypo where P sues D1 for copyright and sues D2 for negligence. That's not non-joinder, that's misjoinder. Non-joinder is when we have a problem under Rule 19, right? That somebody wasn't joined, but they should have been. Well, non-joinder under Rule 19 is a basis for potentially dismissing the lawsuit. But misjoinder is not by itself cause for dismissing an entire civil action. Instead, when you have misjoinder, what the court can do is add parties, it can drop parties, it can even sever a claim against a party, and that would make a separate lawsuit with its own civil action number. Something else a court can do, say joinder is proper, right? So we don't have misjoinder, we don't have a non-joinder problem, but we have a problem because the lawsuit's getting too unwieldy, right? What the court can do is order separate trials for a lawsuit. So say you have one of those crazy cases, right? It's P versus D for copyright infringement. And then D counterclaims for negligence, right? For negligence. And then this person brings in a third-party defendant, asserting contribution, right? And then under 18A piles on a breach of contract for a guitar, all right? All of these can be properly joined, but it doesn't seem like a very good civil action in terms of a trial. Does it really seem efficient to try together the copyright infringement and the breach of contract along with all of the issues related to the car wreck? Seems kind of inefficient, doesn't it? So what the court can do is under Rule 42B is we still have this one civil action, everything is properly joined, but the court can still order a separate trial of one or more claims or parties. Cool. Now I'm not going to get into intervention, I don't spend much time in class on that. I will, however, I'm not going to get into intervention, I'm not going to discuss class actions in detail. What I will discuss very briefly is interpleader. Here, what I recommend to you to do is go back to the handout that I have on the website, marking the distinction between rule interpleader and statutory interpleader. Rule interpleader refers to section to the right of Rule 22, where statutory interpleader refers to the interpleader statute. If you're in a rule interpleader scenario, then we use all of our normal rules for typically diversity, using 4K for PJ, Rule 1391 venue, and no power to adjoin a state proceeding. But for statutory interpleader, it's oftentimes a lot easier to satisfy because Section 35 permits minimal diversity between any two claimants, and the amount of controversy doesn't have to be over 75, but instead 500 or more. You can have PJ over anyone, anywhere within the country, as long as they're served within the country. And we have a special venue rule for statutory interpleader, a district where any claimant resides. And they don't have to all reside in the same state. Note that. It's just any district where any claimant resides. And finally, you can get injunctions with statutory interpleader where the federal court will tell the state court to stop litigating the disposition of the asset. Other things to note about interpleader is that it's not impleader, but rather interpleader. Interpleader refers to when you have a SH, a stakeholder, who has some sort of property that's demanded by one or more claimants, claimant number 1 and claimant number 2. Here, the stake is something that is being claimed by 2 different parties, and the party that actually is in possession of the stake interpleads the other 2 parties so the court can decide who gets possession of the property. That might be a res, like a bottle or a tuba. It might be a stock. It might be a copyright. It might be property, and so on. If this person is also a claimant, we'll call it claimant prime. All right. The law also permits interpleader actions where the stakeholder is also a claimant. We call that in the nature of interpleader. All right, let's see what else. Let's talk about Rule 14. Then I'll talk briefly about Rule 23, and then we'll move on to the next video. All right, Rule 14 is used to bring in a new party, okay? So Rule 14 is kind of like Rules 20 and 19, right? 20 and 19 are used to bring in additional parties that weren't there before. Rule 14 does the same thing. Rule 14 doesn't start off with the TRO standard. To start off a third-party proceeding, the defending party is asserting a claim against a non-party who may be liable to the defending party for all or part of what the defendant is being sued for. And here you really want to pay close attention to the language. So you have, let's get this, there we go. So you have P versus D, then D sues the TPD. All right, well, the defending party, that's this person here, now becomes a third-party plaintiff. Concern summons a complaint on a non-party, that's this person who becomes a third-party defendant, who is or may be liable to it. Of course, who's the it? It is that defendant who becomes the third-party plaintiff. So this person is or may be liable to this person for all or part of what this person is being sued for by the plaintiff. In other words, TPD might be liable to D for all or part of what D is being sued for by P. That means it's derivative liability. The standard here is not TRO. Instead, it's that derivative liability, which is often in either contribution or indemnification. Contribution is going to be under a state statute or state common law. That's when you have multiple tortfeasors, all of whom may be liable in different amounts, right? Indemnification is when you have some sort of at-law right or contractual right, or that gives somebody the right to get recovery from someone else, such as like an insurance policy, right? So you seek indemnification from your insurance policy, or say like a boss. So say a retailer like Walmart is sued because its driver was driving carelessly. All right? Well, here P sued the retailer. Well, the retailer would likely have a right of indemnification against the primary tortfeasor, who was a wayward employee, right? So Walmart would be saying to its driver, saying, hey, I've been sued by the plaintiff, and now you driver, you are or may be liable to us, your employer, via your fiduciary duty, because we have fiduciary duty of indemnification against you because you are a crappy driver and we're ending up being liable by way of respondeat superior. All right, so that's the basics of Rule 14. Things that get interesting with Rule 14, lots of things. I'm not going to go into all the detail. Obviously, the third-party defendant here, like the truck driver, has to assert any Rule 12 defenses or lose them. Has to assert its compulsory counterclaims, may assert its permissive counterclaims. It may assert cross claims if there's other third-party defendants. So if you have P, D, and then you have 2 TPDs, right? Then these folks can assert cross claims pursuant to 13G. Here's one. Third-party defendant can assert claims against the plaintiff. And here's the TRO standard. Just get rid of some of these. Clean up our picture. Claim can run from TPD to PEACE, but it's got to be the same TRO as the original claim, right? Equally so, the plaintiff can sue the third-party defendant, and that's that same T or O standard. Same TRO as the original claim. That's okay too. Now you should note here, the scenario where P sues TPD, that might give, if there's no original jurisdiction, we might have supplemental jurisdiction, but we might be barred because this is a claim by a plaintiff against a person joined under Rule 14, right? That's one of those instances where an SFJ question would require you to be aware of the joinder scenario. Rule 14 plaintiff versus somebody joined under Rule 14, right? All right. What else? I discussed Rule 14A to C in class, but I'm not going to get into that now because that's a longer explanation. So you can ask me about that on Wednesday if you're curious. Last thing I'll note about third-party complaints is, last 2 things I'll note is first, a third-party defendant can join in fourth-party defendants, right? And now TPD would say, hey, fourth-party defendant, you might be liable to me for all or part of what I owe this person, right? That's permitted. Here's something else that's permitted under Rule 14. Third-party claims by a plaintiff. So P sues D for copyright infringement, D counterclaims against P for negligence, and plaintiff now joins in somebody else as a third-party defendant. That is permitted as well, because this is somebody who's a plaintiff who's defending on a claim. We find that under Rule 14b, when a claim is asserted against a plaintiff. See that? Claim asserted against the plaintiff. Then the plaintiff can bring in a third party if the rule would have allowed the defendant to do so. How fun is that? Let's see, what else do we have? Talk about interpleader. Class actions, I teach briefly in class. I highly recommend, if you're interested in doing litigation or complex litigation, take Professor Moore's complex lit class, as she goes into this in way more detail than I do in this class. A couple things worth noting is to have a class action, you have to satisfy Rule 23A, which is prerequisites of numerosity. Usually less than 20 is not going to be enough. Usually more than 100 will be enough. Commonality of law or facts, okay. That's kind of like Rule 28 standard, but much higher because of the case law. Typicality, and here's looking to the claims of the representative parties that are typical of the class. And finally, that the class representatives will engage in fair and adequate representation of the class members. These are just preliminary prerequisites, and by themselves don't allow a class action. Instead, you'd have to satisfy one of these, the mandatory ones under B1, the injunctive or declaratory relief under B2, or the most commonly used is B3, which is typically used for money. All right, and that's a heightened standard. We need first predominance, and second, you need commonality. Excuse me, predominance and superiority. Here we go. Predominance and superiority. Predominance means the common questions of fact regarding the class members have to predominate over the individual questions, and the class action is superior, looking at these factors here. I'm not going to get into the other details of class actions. We covered that in class, and again, if you have questions, we'll take those on Wednesday. Last thing I'll note is under CAFA, there's special jurisdictional rules under 1332D for class actions. You can have a class action involving minimal plaintiff, class members, and the opposing party, so long as you have an aggregated amount of controversy of over $5 billion. There's a lot of additional qualifications to that I'm not going to get into right now, because again, we are on a limited time menu. So let's stop this video. Thank you, and we'll move on to another topic in the next video. Thank you.